I'm Ben Meiselas from the MeidasTouch network. I want to tell you why the decision by Donald Trump to file this motion for judicial oversight before Judge Aileen Cannon and her granting equitable jurisdiction backfired in the biggest way possible and was the single worst legal decision that Donald Trump or any similarly situated person, although it's hard to find a similarly situated lunatic as Donald Trump, but any similarly situated person, it was the worst legal strategy and it backfired in the biggest way. So I want to break it down. So obviously it backfired because Donald Trump lost, right? The 11th Circuit Court of Appeals on December 1st made the ruling that Judge Aileen Cannon should never have had equitable jurisdiction in the first place. But see, I think the Department of Justice was perfectly fine with it being dragged out the way it was. And you may go, why would the Department of Justice want this delay? Isn't that harmful to the Department of Justice? Well, it would have been if the Department of Justice did not get back its top secret, sensitive, compartmented records that Donald Trump stole. If they did not get that back early on in the process, then it would hurt them. But they were very smart and surgical in what they did at the Department of Justice. And let me explain and break it down. So just for a brief background, Donald Trump stole top secret records and thousands of other government records. A magistrate judge signs a search warrant after finding probable cause, after the Department of Justice submits a declaration under oath, an affidavit, and it's received by Judge Reinhardt. Search warrants executed on August 8th. They find the stolen documents. August 22nd, Donald Trump files this motion for judicial oversight. Judge Aileen Cannon grants the motion and asserts equitable jurisdiction, starts this whole special master process. So early on, I think if the Department of Justice actually wanted to shut down Judge Aileen Cannon's process right away, all aspects of it, I think they could have done it right away. I think they could have filed an emergency application with the 11th Circuit Court of Appeals to stay or stop Judge Aileen Cannon's entire special master process if the Department of Justice really wanted to do that. Why? Because she never had jurisdiction, so the process shouldn't have gone forward. And I think the Department of Justice could have validly argued to the 11th Circuit Court of Appeals that they would have suffered irreparable harm because all of their records at issue should not belong to Donald Trump. None of it should go before a special master process. And so there would be all this immediate and irreparable harm. So why even have a special master? Why go through these 4 months? Why waste judicial resources? So I think if the Department of Justice made that argument to the 11th Circuit early on, they could have stopped the process. But that's not what the Department of Justice did because, as I've always said, I think Merrick Garland is a brilliant tactician, and the DOJ under his leadership similarly followed those tactics. And what they did, though, is do a very surgical motion where they did a motion for a partial stay to return just the 100 classified documents, not the 11,000 other documents. And those 11,000 other documents went before a special master that was appointed, Judge Raymond Dearie, and the parties would go through a process where a party would give certain designations and counter designations, and then ultimately a special master would say, should it belong to this party? Should it belong to that party? But you see, the DOJ knew that all the documents belonged to them. Donald Trump didn't really have any arguments at all why it would belong to them. He can't assert executive privilege as a former president. Executive privilege only lies with a current administration. What's he going to claim? Is he going to claim the documents are personal records? If he claims they're personal records, then he's basically admitting to stealing the records and misappropriating them and then claiming that they're his. So what's he going to claim? So they were like, let's have that process before the special master. Let's see what Trump says there. And we're fine with those 11,000 other documents. Let's just see what Trump says there. But let's go to the 11th Circuit. Let's file this motion for partial stay. Let's get back our classified records, which is what we really need. So if the 11th Circuit said, no, you can't get back your top secret classified records, look, that would have been devastating for the Department of Justice. But the 11th Circuit followed the law, and the 11th Circuit said, look, Judge Cannon doesn't have equitable jurisdiction over those 100 classified records because We can go into a much bigger analysis, which I've done in other videos. I won't bore you with that here, but that the factors for asserting extraordinary or anomalous jurisdiction, also known as equitable jurisdiction, you have to find that the government engaged in such a callous disregard for the rights of a person being investigated for a judge to even consider asserting equitable jurisdiction. That didn't exist here. These documents belong to the government. So the 11th Circuit Court of Appeal says, we're returning these documents to the government. So the government's like, great. That's really what we need to continue our criminal investigation into Donald Trump. And they did. They continued to pursue their criminal investigation. They called Kash Patel in, who spoke before the criminal grand jury in Washington, D.C. that's investigating Donald Trump's crimes relating to this theft of government records. Kash Patel, although he talked to Breitbart about how Donald Trump declassified all of these records and how Donald Trump declassified records relating to Russia and national security. When Kash Patel goes in front of the grand jury in D.C., he pleads the fifth. He's granted a what's called derivative use immunity, which is a partial immunity from where he's immune from being prosecuted based on things he tells the Department of Justice and things that they derive from his testimony before the grand jury, but they can still prosecute him for perjury, and they can still prosecute him for things they independently learn outside of what he says to the grand jury. So Kash Patel testifies, and the Department of Justice is getting the information that they want. They got their classified records back, and now they're kind of toying with Donald Trump. And they're doing it intentionally and very sophisticatedly, because now you got a special master judge, Raymond Dearie, who, by the way, was one of the people who Trump recommended, but the Department of Justice was like, we'd be fine with Raymond Dearie. Raymond Dearie, as the special master, is very skeptical of Trump, and he's making the Trump and Trump's lawyers like really put up or shut up. And there was a hearing where Judge Dearie's like, where's the beef? Like, show me what's going on here. And Judge Raymond Dearie would ask the parties to submit briefs about the designations and why are you claiming this document as this. And ultimately, what Donald Trump's initial claims were when he first went to Judge Eileen Cannon, the corrupt Judge Eileen Cannon, who asserted equitable jurisdiction, he had first claimed the issue really involves executive privilege and attorney-client privilege. But it was obvious that none of that was the case. He then kind of switched his arguments, and he was not thinking ahead. Like, he was playing like checkers wouldn't do it justice, while Garland was playing like 8-dimensional chess. Like, Trump was playing, he was just throwing pennies in water. I don't even know what he was doing. There was no strategy there. So Trump then changed the strategy, and they started claiming, because I guess they just adopt whatever they hear on the right-wing echo chamber, which doesn't work in courts, just claim that under the Presidential Records Act, just say that you as a former president can literally just steal anything and then claim it as a personal record. So what Trump was hearing from the right-wing echo chamber was, look, as a former president, you can do whatever the heck you want. Just say they're personal. And if you claim they're personal, then they're yours, which is not what the law is. The Presidential Records Act has a very specific definition of what's a personal record and what's a presidential record. And that's very clearly defined. So Trump saying, well, these classified records or these government records are mine is an absurd argument would be an absurd argument to make. But nonetheless, the Department of Justice kind of lured Trump into making those absurd arguments and, frankly, incriminating arguments as Donald Trump tried to focus on how he could try to win before Judge Raymond Dearie while not thinking about the fact that he was incriminating himself further, or maybe he wanted to incriminate himself further. I don't know, but further incriminating himself with these ridiculous right-wing conspiratorial arguments, but now putting forward statements the Department of Justice would never, ever get. Look, if you were representing Trump or anybody in a situation like this, so as a lawyer, that was my client, and it pains me to even think about Donald Trump being a client, but let's just say someone similarly situated, you would tell him, do not say anything. Like, do not talk, do not post, do not mention anything. You have a Fifth Amendment right against self-incrimination, and utilize that Fifth Amendment right. Do not give the government any additional information. Do not give the government any data. Let the government build their own case and investigate the case, but don't help the government out. Like, That's the advice a criminal defense lawyer would give to someone in that position, not admit that you stole the records. And so because these special master proceedings were taking place and Judge Raymond Dearie was a no-nonsense judge as the special master, Trump started filing these briefs and kind of took the bait that was there and started really responding to these things by further incriminating himself. So here, let me read for you. This is from a brief that Trump filed before Judge Raymond Dearie. And let's go to the page where he talks about why these documents belong to him and these records belong to him. He goes, in this instance, President Trump exercised that authority. As initial matter, the Presidential Records Act recognizes the president's authority to make this decision, and when that decision is made, it is not subject to challenge. There is no authority whatsoever for the notion that the government can seize documents from a president and simply declare that they are presidential records. Furthermore, plaintiff is not referencing any authority to designate documents as presidential records or personal records after his term in office. Rather, plaintiff was authorized to and did in fact designate seized materials as personal records while he served as president. President Trump was still serving his term in office when the documents at issue were packed, transported, and delivered to his residence in Palm Beach, Florida. Thus, when he made a designation decision, he was president of the United States. His decision to retain certain records as personal is entitled to deference, and the records in question are thus presumptively personal. That's page 5 from a brief that Trump filed on November 8th, 2022, before the special master judge Raymond Dearie. He totally doesn't understand what the Presidential Records Act is. The Presidential Records Act doesn't allow presidents, former presidents, or current president. You can't steal records and just claim that they're yours. Like, that's utterly absurd, but that's what they're claiming here to try to win before Judge Raymond Dearie, which they're not, which they were going to lose. And they ultimately did lose because Judge Eileen Cannon lost jurisdiction. Raymond Dearie, therefore, doesn't have jurisdiction either. But what they literally admit to here is saying when Trump was still president, he packed, transported, and delivered to his residence these documents at issue. And the claim is, and it's an absurd one, that by taking documents that didn't belong to him, putting it in a box and shipping it to Florida, that then kind of transmuted the property from a government record and a presidential record to a personal record, which is utterly absurd. And so in addition to those statements that were in filings that are now incriminating to Donald Trump, whereas he should have just been quiet, he had the right to remain silent, the Department of Justice now has information like that they would never otherwise get. Trump also started posting things, and go doing interviews. You remember the interview he did with Sean Hannity where he talked about, because he didn't understand like classification and declassifying. And so because they didn't understand the law, one of the things that they were arguing during this whole process is that he declassified all of the records, even nuclear records, like everything he declassified. And because he declassified it, there's no crime. That totally misunderstands what the law is. Under the laws that Donald Trump is being investigated for violating, Espionage Act, obstruction, mutilation, and destruction of records, the classification status of the records doesn't matter, whether it's declassified or classified. The very essence of it is you're stealing government records that don't belong to you. So nonetheless, Donald Trump then went on this whole kind of rant about declassifying records through telepathic powers. Again, that's all being lured by the Department of Justice, kind of embracing this process before Judge Raymond Dearie, rather than shutting the whole thing down right away, which again, I think they could have shut it down like within weeks if they really wanted to. The same way within weeks they shut it down as it relates to the top secret classified records, which they got returned back. Why wouldn't the Court of Appeals just say, if she doesn't have jurisdiction there, if the DOJ asked them for the others, why wouldn't they just shut it down for the other 11,000 records? I mean, I think they would have made that ruling if that's the way the DOJ wanted to go. So like that's what Trump talked about on Hannity. And then he did like 1 million posts on his, like, not actually 1 million, but like maybe like dozens or hundreds, where he then had all these incriminating posts on his social media platform. Like, here's a recent one that he just wrote. like within the past 24 to 48 hours. He wrote that we live in a very corrupt country, as they are saying all over the internet. Nothing will be done about it because our Justice Department and FBI are totally corrupt, but they'll keep investigating, quote, boxes that were legally and openly taken from the White House. This is in the past 48 hours. Again, admitting to stealing the records. I could show you a dozen more of those, but I'll save you the time. But all of that is now becoming evidence against Donald Trump. And the fact that Donald Trump, rather than when the search warrant was executed at Mar-a-Lago, all he had to do at that point was just shut up. The Department of Justice would have engaged in his investigation. He didn't have to file this motion for judicial oversight, but he felt he had to because he was hearing on right-wing social media and on right-wing TV by people who are horrible lawyers and people who are not lawyers but who act like lawyers. Oh, get a special master and have them deal with it and petition this from Judge Eileen Cannon. And by the way, Judge Eileen Cannon should never have granted it, but she was so corrupt, she thought she was helping Trump, and she was doing the exact opposite of helping Trump, because now you got all these incriminating statements that are on the court docket. You have all of these incriminating statements that Trump made in interviews. You have all of these incriminating statements that Trump has made at rallies. You have all of these incriminating statements that Trump has made on the social media posts, but specifically in the docket, his position that he took the records and that he's now claiming them to be personal records because he stole them is not a helpful factor for him. It's a great factor for justice and for his accountability. So overall here, the fact that this process took essentially 4 months, right? Judge Cannon granted the motion for judicial oversight on September 5th. By October, the DOJ got its classified records back. By November, the briefing was done on their overall appeal. By December 1, the entire thing is shut down. Judge Eileen Cannon was ruled to have no jurisdiction. The special master process thus comes to an end. But all of this incriminating action comes out. Now, what do you think would have happened if after the search warrant was executed, the Department of Justice then subpoenaed Donald Trump to show up before a grand jury the same way they subpoenaed Kash Patel? Trump wouldn't show up. He would assert the objections, and maybe he would plead the fifth, and that would take months and months and months to happen, right? But during these months and months and months that have transpired, what Merrick Garland was able to engineer was to set this trap for Donald Trump, which Trump just bought hook, line, and sinker, and where Trump's horrible lawyers, or because they're horrible or just were unable to stop him from falling into the trap, he gave essentially the Department of Justice all of the questions that they would have wanted to ask him in the grand jury that he never would have answered and he would have tried to avoid. They now have that in addition to having pursued all of their investigatory avenues that they needed to before. The delay did not hurt the DOJ at all. The delay helped the DOJ. The delay was disastrous. Oh, by the way, I could have talked about all of the statements also made by Trump's lawyers like Alina Habba and Christina Bobb, who went on right-wing media like Fox and OAN and Newsmax, and they also lied and talked more about all of the incriminating stuff that Donald Trump did. So all of that stuff is now evidence. The DOJ doesn't have to take the depositions. The DOJ didn't have to call them in. It was just handed to them by this really ridiculous, horrible defense strategy or offense strategy that Trump employed here, and a brilliant strategy by Merrick Garland to be surgical, lure the trap, and get Trump to say all of these things. So justice is moving in the right direction, but I want to explain to you why all of these things that have happened, though, was a brilliant legal maneuver by Merrick Garland. Like, you almost got to respect it so much. I'm Ben Meiselas from the MeidasTouch Network. Hit the subscribe button. We're on our way to 1 million subscribers thanks to your support. Please hit the subscribe button. And in addition, consider joining us on Patreon. Go to patreon.com/MeidasTouch. Become a patron. That's a paid membership over at patreon.com/MeidasTouch. We're not funded by any outside investors at all. So if you can do it, no matter where you are in the world, I always hear you say, what can we do to help? I know you have lots of subscriptions that you're signed up for, but this is one that will help Support this network, support this community, only if you can do it. Check out patreon.com/MeidasTouch. Until next time, I'm Ben Meiselas.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.